Welcome to K&L Gates Working Wise podcast series. My name is Dan Hurley, and I'm a partner in the Seattle office of the firm's Labor, Employment, and Workplace Safety Practice Area. In this podcast, I will be discussing some general issues for employers to be aware of regarding the ever-increasing number of state and local laws requiring employers to provide paid sick leave. Interestingly, according to the Bureau of Labor Statistics National Compensation Survey, in 2016, around 70% of civilian employees received some form of paid sick leave from their employers. This general group includes private employers in the non-farm economy and workers in the public sector, excluding the federal government. Perhaps not surprisingly, within this group, the percentage is higher for management, professional, and related categories of employees, with about 88% receiving paid sick leave, compared with employees in the service category, for example, with about 49% receiving paid sick leave. And the number for full-time employees within the broader group is about 81%, compared with only 33% for part-time employees. At the present time, no federal law requires private employers to provide paid sick leave to their employees, although there are regulations that require certain employers that contract with the federal government to provide their employees with paid sick leave. So employers who contract with the federal government will want to determine whether they are covered by those regulations. In the absence of a general federal law requiring paid sick leave, in recent years a number of states, cities, and counties have passed laws requiring employers to provide paid sick leave. The following 9 states have broad laws requiring employers to provide paid sick leave: Arizona, California, Connecticut, Maryland, Massachusetts, Oregon, Rhode Island, Vermont, and Washington. Additionally, more than 30 local government authorities have enacted paid sick leave laws, notably including, for example, New York City, several cities in New Jersey, San Francisco, Los Angeles, Seattle, Philadelphia, Pittsburgh, Minneapolis, Washington, D.C., and Cook County, Illinois. Accordingly, employers with operations or employees in such locations will want to determine what obligations they might have to provide paid sick leave. Employers in many locations face the additional challenge of being subject to both state and local laws. Examples for me here locally include employers being subject to both the new Washington state law that went into effect just this year and the paid sick leave requirements enacted by the cities of Seattle, Tacoma, and Spokane. Given the potential complexity and the associated burdens for employers when multiple paid sick leave requirements exist, many states have enacted laws preempting local laws regarding paid sick leave. Currently, about 20 states have such laws, with some of these states having enacted laws that both require employers to provide paid sick leave and preempt local laws requiring paid sick leave. Examples there include Arizona, Oregon, Maryland, and Rhode Island. Other states, such as Louisiana, Wisconsin, and Alabama, have passed laws preempting local sick leave laws despite the absence of any state law requiring paid sick leave. In short, the proliferation of different laws in different jurisdictions creates additional administrative and financial burdens on employers, particularly those that operate or have remote employees in many different states. For such employers, they must understand and comply with the applicable sick leave laws in each location, and it can be difficult to have one policy that applies to all employees. Of course, a comprehensive listing of state and local paid sick leave laws and a summary of their requirements is beyond the scope of this podcast. Rather, our purpose today is to talk generally about these laws and to address some of the typical issues of which employers should be aware. In a general sense, from my particular experience in Washington, where we have a new state law in effect as of January 1 of this year, and where cities of Seattle, SeaTac, and Spokane have local laws, employers sometimes make the error of assuming that if they already allowed for the accrual of paid sick leave prior to the existence of the state and local laws, then they are in compliance. In fact, however, even if an employer had a pre-existing policy that provided for accrual of paid sick leave at rates meeting the minimum standards in the new Washington state law, the employer's policy still may not be in compliance with the applicable requirements of that law. With that example, I would like to speak categorically about some common provisions and issues related to state and local paid sick leave laws. With respect to any applicable law requiring paid sick leave, common questions for an employer to consider should include the following. Question 1. Does the law apply to my company? Importantly, some paid sick leave laws will only apply if an employer has a minimum number of employees, say 15, while other laws include no such minimum, but may have different required accrual rates based on a company's size. A related question that can be important for employers with employees working remotely in a state or city with a paid sick leave law is whether an applicable minimum number of employees for the law to apply includes in that count employees in other locations, whereby an employer might have only one employee in a location with a paid sick leave law, but if there are a sufficient number of employees working outside that location to meet the minimum threshold number, the paid sick leave law requirements will apply to that one employee. Question 2. Does the law apply to all or some of the company's employees? Paid sick leave laws often specify a certain minimum number of hours that an employee must work to be eligible to accrue and use paid sick leave. Some laws also exclude categories of workers, such as exempt salaried employees or short-term employees. Issues also arise here with regard to temporary employees who may be employed by a staffing agency and then assigned to another employer. Under some paid sick leave laws, if the staffing agency does not provide for the accrual and usage of paid sick leave, the company for whom the staffing agency employees are assigned may be deemed to be a joint employer and thus potentially liable for the agency's failure to provide paid sick leave. Question 3. What does the law require in terms of the accrual rates for sick leave? As noted, accrual rates vary across these state and local laws, and rates may vary within a given law based on the number of employees, the number of hours a given employee works in a given location, and whether the employee is exempt or non-exempt from minimum wage and overtime pay requirements. Question 4. Under what circumstances does the law entitle an employee to use paid sick leave? I have found this to be an area of potential noncompliance for a lot of employers who do not closely review and, if needed, alter their pre-existing policies, and rather simply assume they will be in compliance if their accrual rates meet the applicable minimums. For example, paid sick leave laws typically define broadly the circumstances where an employee must be allowed to use paid sick leave. Such laws commonly allow an employee to use paid leave for his or her own illnesses and medical appointments, as well as to assist a family member who is ill or attending to a medical appointment. And again, here you have variances in who is included within the definition of a family member. Some laws also allow use of paid sick leave in situations where the employee is a victim of domestic violence, stalking, or abuse, or where the employer's place of business or child's school is closed by order of a public official. Question 5. What notice obligations can be imposed on employees seeking to use paid sick leave? In this area, most sick leave laws have different requirements with respect to foreseeable needs for sick leave, such as a surgical procedure that is planned well in advance, compared with an unforeseeable need, such as a routine illness like the flu or a sudden injury or medical condition. For example, sick leave laws often include a maximum number of days advance notice an employer can require for foreseeable leaves, and contemplate that in unforeseeable circumstances an employee may have little or no advance notice of the need for paid sick leave. Question 6. Does the sick leave law impose limitations on what documentation an employee can be required to produce to support use of paid sick leave? This is another area where an employer who is not careful can easily run afoul of a sick leave law. For example, in Washington and Arizona, an employer is generally not allowed to request documentation to support an employee's use of paid sick leave unless the absence is for more than 3 consecutive days. And where documentation can be requested, these paid sick leave laws include specific requirements and limitations on the type and timing of such documentation. Question 7. What does the law require with regard to caps on and carryover of accrued paid sick leave, as well as handling of unused sick leave on termination of employment? There's variance across the state and local laws as to whether an employer can cap accrual of sick leave and whether an employer is required to carry over unused paid sick leave from one year to the next. Additionally, some sick leave laws provide that employers need not cash out employees for any unused sick time on termination of employment, while other laws may require payment on termination. Question 8. What does the law require in terms of providing employees notice of applicable sick leave entitlements and posting of applicable legal requirements? Most laws provide some specification as to the employer's obligations to communicate their own sick leave policy and to inform employees of the applicable legal requirements. In many cases, this includes an obligation to post in a conspicuous place a notice that is published by the agency charged with enforcement of the applicable paid sick leave law. Question 9. What does the law require in terms of record keeping regarding accrual and use of paid sick leave? For example, sick leave laws commonly require employers to inform employees regularly, perhaps with each pay statement, of the amount of available paid sick leave they have and the amount they have used in a given period of time. Question 10. What does the sick leave law provide in terms of enforcement? Paid sick leave laws typically provide measures for investigation and enforcement by a local agency, including specified fines or possible individual rights to seek remedies in state or local courts. Employers should be mindful of the potential liabilities that could arise here, particularly when those liabilities might be multiplied by each employee and each instance of noncompliance. Additional question to consider here is whether an employer can satisfy the requirement to provide paid sick leave through a general paid time off policy where employees are allowed to accrue time off that they can use for a variety of reasons, whether it be for traditional sick leave or for vacation or personal time. Most paid sick leave laws expressly allow for an employer to use a PTO system to satisfy the paid sick leave requirements, as long as that system allows employees to accrue and use leave on terms at least equivalent to those specified in the law. Of course, the difficulty here is that a pre-existing PTO policy is not likely to comply with all of the various requirements of the applicable paid sick leave law. Of course, there are a number of other issues to consider, such as the need to protect confidential information collected from employees to verify the need to use paid sick leave, and whether sick leave can be loaned or advanced to or between employees. It's also important to note that most paid sick leave laws prohibit retaliation against employees for using paid sick leave or otherwise asserting their rights under the applicable paid sick leave laws, thereby creating a new material risk that a terminated employee might claim his or her termination was retaliatory, transforming relatively minor obligations related to accrual and use of paid sick leave into a potentially material liability for a wrongful termination. In closing, it's important for an employer to determine whether there are any state or local paid sick leave laws in locations where the employer has operations or employees working remotely. If there are, the employer should not assume that, if it already provides paid sick leave, that it will be in compliance with those laws. Rather, employers need to take the steps necessary to determine whether their paid sick leave policies meet the requirements of applicable law or laws, and if not, to implement the necessary changes. While the various state and local sick leave laws typically make clear that they do not require an employer who already provides paid sick leave to offer additional paid sick leave in order to comply, they all generally do impose very specific requirements with regard to accrual, use, caps, and carryover of sick leave, among other requirements, that may necessitate changes to an existing policy. In closing, we hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.